Welcome back to Intersection, a program of KBIA and the Reynolds Journalism Institute. I'm Ryan Ferguson, and today we're talking about the Ryan Ferguson case. Last week, a court of appeals threw out Ferguson's conviction in the 2001 murder of Columbia Daily Tribune sports editor Kent Heithold. Today, we're talking about the legal basis for why that conviction was vacated and some of the larger issues surrounding the conduct of prosecutors. Join me in studio for the conversation today are Bill Ferguson, the father of Ryan Ferguson, Rodney Uphoff, a professor in the MU School of Law and a former public defender, Attorney John Roothouse, who in the past worked as a Boone County assistant prosecuting attorney and as an assistant attorney general for the state of Missouri, and joining us by phone, Charles Atwell is a practicing attorney who was formerly a circuit judge in Jackson County. And for you and our audience, what should be done to prevent wrongful convictions from happening? Give us a call at 573-882-8925 or email intersection@kbia.org. You could also tweet us at intersectkbia.
Ryan,
Charles, yes, go ahead.
I wanted to segue off of some of the comments that we've talked about, and I think that Rodney talked a lot about the idea of impeaching evidence being Brady, and I think that the Supreme Court has held since I think the early '80s in a case called Bagley that impeachment evidence does encompass the Brady concept, and I think this is a real problem in that there are a lot of prosecutors, I think, who probably can understand that if they get evidence that directly shows someone else did the crime and is directly exculpatory, that to them is sometimes a different thing than this what we call impeaching evidence, because the impeaching evidence attacks the credibility of their case. And I really think one of the things that needs to happen is that prosecutors need to understand that the breadth of Brady and that it does affect impeaching evidence, and that impeaching evidence can result in injustice and can result in a set aside in this circumstance. And I think the thing that the public needs to understand in this regard also is that I really feel there's a lot of times where there's impeaching evidence is that rather than judge's materiality now, wouldn't it have been better to have disclosed it? And at the time when all the witnesses' memories are fresh, when the evidence is fresh, and it can be dealt with in the most appropriate way, and in some situations, if from a prosecutor point of view, if you don't give up this impeaching evidence, you run the risk of down the road is having someone exonerated or at least released, and you really don't have the ability to retry the case because of the fact it's old and the witnesses' memories fail and the like. So I think this impeaching evidence thing is really something that's not looked at a lot and is really a much bigger deal, and it should be on the forefront of training for prosecutors. And I think it's where a lot of injustice occurs. And
just briefly, could you explain what impeaching evidence is, again, for the non-lawyers?
Well, impeaching evidence would be, in other words, a direct exculpatory evidence would be, the defendant didn't commit this crime, John Jones committed this crime. But impeaching evidence would be if there's a witness saying John Jones committed the crime, but there's a statement where the witness, for example, like in Kyles versus Whitley, where he named someone else, or he had made inconsistent statements, and so that some of the key evidence is not near as believable as it was presented in the trial itself.
Well, I think he makes an excellent point, and this is one of the problems I think that I have with this case is that I agree that if it was in the prosecutor's possession, he should have erred on the side of turning it over. But in this particular case, you had a non-lawyer that had to make a determination as to whether this was impeachment evidence or not, because this never got to a lawyer's ears. And the way that the decision is written, in this case we had an investigator who had a great deal of experience, and so we might expect him to be able to determine impeachment evidence from not. But what if this would have been just a call to a secretary or to the victim's advocate? The way that Brady has been interpreted, that would be imputed to the prosecutor. Mm-hmm. And I don't think it's realistic for us to expect the staff of the prosecutor's office to be able to make on-the-spot legal determinations as to what is impeachment evidence or not as a matter of law. In fact, in this particular case, I would say as someone who's tried several cases myself that involve impeaching witness testimony, I would not have used Mrs. Trump, because if she were asked, if I were defending Ryan and if she were asked under oath, did you send this newspaper to your husband in jail? And she said, oh, I don't remember sending that newspaper. I don't remember that. that I think would be very counterproductive to my case. I mean, I would want someone that would say affirmatively, no, I did not send that newspaper. I have nothing to do with that. My husband never saw a newspaper in jail. So I think this decision does, I think, create a lot of problems going forward. It's not just your run-of-the-mill Brady case.
Well, but it's not the run-of-the-mill because of their evaluation. I mean, again, and I'm not a student of the case, but it's really an evaluation of the materiality of the situation. The fact that impeaching evidence as Brady has been established for a long time and should have been given up. I mean, we're parsing words and using legalisms, but I think that's really more like what we've got here.
Yeah, that's kind of what I was saying. I think the fight here is the significance of the material withheld. Although, John, I mean, I think what the court was doing in Kyles versus Whitley was trying to essentially send a clear signal, clear message to the prosecution that because this is a problem that we've seen over the years with material not getting the defense and there being various justifications, explanations for why that it didn't get there, it essentially is imposing almost a strict liability standard on the prosecutors, saying it's incumbent upon you, Mr. Prosecutor, to set up policies and procedures so that those decisions are made by not by the secretary or the witness advocate or the investigator, but the decision is ultimately made by the prosecutor. So the message that ought to go out is if you get calls from witnesses, put something down, send it to us, and then we'll let you know whether you need to file a complete report or whether or not we've got to do some additional checking. We as the prosecutors do additional checking before we need to turn something over. But I agree, we don't want the decisions made at the by the individual investigator. We want them to be made by the prosecutor, but we've got to get that information to the prosecutor so he or she can make the right decisions.
Right. Well, how does those types of disclosures, how does that actually happen here in Boone County, I guess, currently? How does that process actually work, those disclosures, when they're being presented to the defense?
That's the ex-prosecutor.
John.
Well, I can tell you what happens in your run-of-the-mill case,
okay.
And it is akin to an open file system. Essentially, there are certain documents that we are not permitted to disclose. I say we, I'm a criminal defense attorney now, but I'm slipping back into my past persona here for the show. There are certain documents that can't be turned over as far as criminal background documents,
Sure.
and there's some information about witness information can't be given over. But
Sure,
otherwise,
privacy.
Everything else, the policy is that the secretary runs a photocopy of everything, puts a cover letter on the top, the prosecutor looks it over, signs it over, and any subsequent supplemental reports that come in, same way. I think it's actually, when it comes into the office, a copy gets made for the prosecutor and the other copy goes directly to the defense attorney. Mm-hmm. Now, in a big case like this, I understand it may be different, and I can't really comment on that.
Sure.
I think the problem, and I think John has really identified a real key systemic problem, and that is John identified the way it's handled probably in 90% of the prosecutor offices around the country. It's certainly the way it was handled in both Oklahoma and Wisconsin, where I practiced for quite a bit of time. The problem tends to be when there are supplemental reports or supplemental conversations that didn't generate a report. Those are the situations where you're more likely to get exculpatory material, but the individual investigators or police officers don't necessarily recognize this information as exculpatory, because one of the key problems that keeps being identified in these exoneration cases, and I'm referring to the 311 DNA exonerations, there's more if you count other cases where a fair trial didn't necessarily happen. But in these exoneration cases, the problem is the police have fixated on a particular witness. And so they're hearing other information come in, but it's not consistent with their theory of the case. It's not consistent with their strong belief that John Jones was the murderer or the rapist or whatever. And so it never finds its way into the file because it seems irrelevant to them. And that's the root of the problem.
Yeah, and that's what some would say. The problem is an overzealous prosecutor. Is that part of the equation here, or in some situations they can't? I mean, again, some people are following the letter of law as they should, but this opens up that territory for someone like that.
Well, there certainly are cases of the overzealous prosecutor, the overzealous, where we actually have people who intentionally sometimes destroy or conceal exculpatory material. I'm identifying what I think is the more common problem, and that is the tunnel vision problem, where they simply don't recognize the significance of this information because they're fixated on a particular person. So they're not necessarily, this is the classic, not necessarily acting out of bad faith. They just don't see the exculpatory nature of material. And then in hindsight, the defense lawyer or the court looks at this and goes, well, duh, it's so obvious this should have been turned over, but it just didn't seem that obvious at the time when the investigator or the police officer was looking at it. So those are two very different situations. Purposeful misconduct, hiding material, and then the failure to recognize the significance of the exculpatory material.
And in fairness to the courts, too, I'll say, is that they have recognized some limits to Brady. Probably the most common in Missouri is when the defense otherwise knows of the information that it's been failed to be disclosed. This was in the Salter case of Missouri Supreme Court, and then that was affirming Myers in an earlier decision, which basically says no harm, no foul. If the defense knew about the information through some other channel, the prosecutor may have committed a violation, but the point here is not to punish the prosecutor. Not the point is to see whether or not the defendant had due process in this trial. So I guess what I would like to see in a case like this one is let's acknowledge the fact that Mr. Trump was deposed prior to trial, that he spoke at his deposition about seeing this newspaper that his wife allegedly gave him. The defense had every opportunity to investigate this and to create its own impeachment case against Mr. Trump. And I think that to put the burden completely on the state using a hindsight analysis is just not realistic. We can disagree as to whether it was material or not. I don't think it was. You may think it was. But the fact is that there's no dispute that had a diligent attorney conducted the deposition and followed up on what was testified to at the deposition, the defense had every opportunity to know this information.
That's an interesting point, because I will say that this is a rare case. Now, Bill Ferguson and I may disagree on this, but the defense in at Ryan's trial, it's one of the high-profile criminal defense lawyers from Kansas City. It was a team that was adequately resourced. It was a team that brought in Elizabeth Loftus, one of the country's leading expert witnesses. It's a much different kind of defense than you generally see in a lot of the wrongful conviction cases. So one of my problems is, and this is not focusing on Ryan Ferguson, but the larger systemic problem of the failure to turn over exculpatory material is we've got lots of public defenders with large caseloads who don't have access to investigators, who don't really have the ability to use depositions because of their caseload problem. So their ability to discover this exculpatory material is in a much different position than the Ferguson case. So I'd like to move off the Ferguson case if we could for just a minute.
I think so.
And I feel your pain with that too, but I think that there's that same pressure on the state side, not in a big case like this, but in the run-of-the-mill case. You've got an assistant prosecutor with hundreds of cases, and like I said, in every trial, the prosecutor who's trying the case is getting a phone call from a witness that is starting to waver on whether they want to cooperate or not. Now, maybe something that they testified to before. Well, I don't remember. I don't know if that's what I said or not, or I don't know if that's what I said or not. Do we need to make a memo every single time someone calls?
Charlie, what do you think about that situation? If I come in front of you as a judge and I have a prosecutor who got a witness who previously said in their police report, I'm 100% sure that the defendant is the guy. Now they've made a call to John, and during that call, they're now retreating, and they're saying, I'm really not sure. Doesn't John have a statutory and constitutional obligation to memorialize that and turn that over to me?
He certainly has. I believe he has an obligation to turn it over for sure.
What if by the end of the phone call, the witness has acknowledged the fact that, okay, I'm going to go through with it. I'm going to show up. Do you really need me to testify? Okay, I'll show up.
See, I think there's a big difference between wavering in terms of their enthusiasm for testifying, which I bet happens pretty commonly, and they're saying they're now not sure that the person that they once said was 100% sure. Now they're saying, hey, I think
But those two go hand in glove. They go hand in glove because they know that the way that they can get out of testifying is if, okay, well, if I don't say what the prosecutor wants me to say, maybe he won't make me testify.
I think there's two. One is the one question, is there an obligation to produce? And I think good practice suggests yes. Okay? And then the other area is, again, we can get back to this materiality. In other words, did it make a difference? And I think that's the other thing that Rodney talked about. In the Kyle's case, not only did they suggest that prosecutors need to investigate beyond their own knowledge, but I think a fair reading of Kyle's is that they lessened the materiality standard because they were seeing a lot of these Brady violations.
All right. I do want to take a moment to remind our audience this is Intersection, a program of KBIA and the Reynolds Journalism Institute. I'm Ryan Ferguson, and today we're talking about the Ryan Ferguson case. Last week, a court of appeals threw out Ferguson's conviction in the 2001 murder of Columbia Daily Tribune sports editor Kent Heitholt. Today we're talking about the legal basis for that conviction, why it was vacated, and some of the larger issues surrounding the conduct of prosecutors. Joining me in studio for the conversation today are Bill Ferguson, the father of Ryan Ferguson, Rodney Uphoff, a professor in the MU School of Law and former public defender, Attorney John Roothouse, who in the past worked as a Boone County Assistant Prosecuting Attorney and as an Assistant Attorney General for the state of Missouri. And joining us by phone, Charles Atwell is a practicing attorney who was formerly a circuit judge in Jackson County. And for you in our audience, do you think prosecutors should be punished if they commit a Brady violation? Let us know by giving us a call at 573-882-8925 or email intersection@kbia.org. You could also tweet us at intersectkbia. And that actually question goes well with a comment we did get from a guest in the chat room. It says, what should be done to prevent Brady violations from happening? Hold prosecutors responsible. Maybe let's start with Charles on this, since Charles is on the phone. What do you think about that sort of that sentiment, Charles?
Well, I think that if there are Brady violations, I think that if someone commits an obvious Brady violation, that it's certainly at a minimum that office should be slow to use that person in a sensitive situation again, or at least should be very cautious about it. Prosecutors do have, for the most part, civil immunity on these things, so there's not really a basis to sue them or get compensation for them. The one classic example is there was, based on all these exonerations that occurred in Illinois on the death penalty, all the death penalty exonerations, there was actually a prosecution of several prosecutors and court officials in a place called DeKalb County, which is I believe, just to the west of Chicago. And there were prosecutions. Those defendants happened to have been acquitted, but that did occur on one occasion.
But that is pretty rare, right? I mean, there aren't a lot of systematic practices.
And sadly, what happens sometimes is there are prosecutors today that have committed Brady violations, maybe minor ones or maybe ones that didn't result in an injustice, but they're still prosecuting. There are folks like that now. There are also, to segue what I think Rodney said is, I have seen circumstances where prosecutors have produced Brady evidence and have been the main movers in exonerating folks. That has happened. I know I've been involved in two particular ones where it did happen.
Sure, I think that's a really important point, Charlie, because I'm certainly not trying to suggest, and I don't think John and Charlie are trying to suggest either, that prosecutors are always the bad guys who are always violating the rules, because, as I opened up by saying, the vast majority of prosecutors follow the rules, play by the rules, and do their job appropriately. And Charlie's exactly right. There are examples of prosecutors who have reopened cases, and they've been the main engineers of exonerations. But the systemic problem is, how do we deal with those prosecutors who aren't playing by the rules and are violating the rules? And as the criminal justice system has not done a very good job in policing those prosecutors. If you look around the country, there are very few instances where professional misconduct has been levied against prosecutors, not in the close calls. I'm talking about the egregious cases, as the example in Texas. That's a rare instance where a prosecutor has been disbarred. The Duke Lacrosse rape case is another one where Mike Nifong was disbarred for his egregious concealing of evidence. But civil liability is not a route, because currently most of the laws in the country provide virtually absolute immunity, for prosecutors, despite their misconduct. we don't want to get ourselves, unfortunately, in the dilemma of having to choose between holding them accountable or dismissing cases. I mean, I think we've got to find a mechanism, and I think it's through the professional disciplinary committees that ought to be holding prosecutors accountable when there's a clear violation of the rules.
I'm going to go ahead and bring in. We have a caller on the line, Carolyn from Columbia. Carolyn, are you there?
Yes, I am.
Hi. Thanks for calling in today.
Yes. I just wanted to say, partly speaking as a citizen, but I have to admit I'm also an attorney and give a disclaimer that I can't possibly say that I know all the details of the case. But it is my impression that there have been so many problems with the witnesses and so many recurring problems with the evidence that bringing this whole case back around to the Brady issue is the right thing to do, because it appeared to me it was not beyond a reasonable doubt. And as for prosecutors, I think in Boone County we're blessed with basically a very good team of prosecutors. But yes, it is a nationwide problem, and something needs to be figured out to close the loopholes where evidence is not brought forward or not logged into the file, or et cetera, et cetera. So I think there's a lot that's being said that's very valuable here today. Thank you.
Okay, great. Thanks, Carolyn, very much for calling in. Bill, I wanted to give you a chance to jump in. You'd been trying to many times this half hour. A lot going on.
Yeah, and some of those points have come and gone. But I think, can I help but think, I think someone said in Chicago that there were 300 and some odd people that were exonerated. You know, it seems like to me if you have 300 people that were exonerated, the prosecutor either knew or should have known that there was a problem. That's a problem. I think that we're on the brink of the Enlightenment period of examining prosecutors a lot closer, because I think they've been getting a free go for a long time. When we talk about setting a mechanism in to make sure this doesn't happen, we definitely need to do that. And they're not being diligent in the running of their offices unless they do that. And I was asked in New York in an interview, they said, what do you suggest we could do to bring this about? And I suggested fairness about. I said, if you would find a prosecutor has done something egregious, and I don't think that's very hard to do, and send him to prison, not 10 days like in Anderson's case, send him to prison for 5, 10, 15 years or what happens to be, I think that would have a cooling effect on misbehavior. And I just don't want to hear people justifying the prosecutors and hedging things and so on and so forth. We've got too many people doing that. Let's look at the guts of the case. Some of them are absolute pure liars. Not all of them. Take, for example, the John Bonet case. 2 prosecutors there. Initially, whenever the grand jury wanted an indictment, they said no. The prosecutor said no. And whenever Mark David Carr admitted that he was there when the murder took place in Singapore, and flew him into Colorado and found out he'd never been there before, they never pursued that. If that had been in Boone County, he'd be in prison right now.
Well, in all due respect to Mr. Ferguson, I mean, I don't have the personal stake in this case as he does, and with the Boone County Prosecutor's Office like he does. But that's just a fairy tale, what he just described. I mean, the prosecutors don't act like that on a widespread level. I'm just trying to think off the top of my head in the state of Missouri. I think in the past 10 years, there have been 3 or 4 cases reversed. I mean, Rod would probably know better. Less than 10 cases have been reversed on Brady violations in the past 10 years. So, I mean, this idea that we have this widespread national problem of prosecutorial misconduct is really just a fairy tale.
You wouldn't call 300 in Chicago a wide problem? That's insignificant?
Again, I don't know what we're even referring to when we're talking about 300 in Chicago.
I thought you said
that was in the intro, and that I don't think that it was a Chicago Tribune article. But I'll tell you what. From here, I want to move. We have a few minutes left. Why don't we jump into this question, because it might be a good summary question here. We talked a little bit about holding prosecutors accountable and how that's kind of tricky because of immunity. What could be done to try to fend off more Brady violations? If that cooling effect is a difficult one to come by, what else can be done at this point in the game?
Well, I think the most effective way to hold prosecutors accountable is through the boards of professional misconduct in the individual jurisdictions. And some jurisdictions are more aggressive in going after prosecutors. than other jurisdictions. Oklahoma was a place I'm very familiar with. The prosecutors down there could pretty much do whatever they wanted to do. The chief prosecutor in Oklahoma County was found by the 10th Circuit to have lied in court in a death penalty case. They overturned the death penalty case, found that he, as I said, he lied to the court during the proceeding. Well, if a criminal defense lawyer or a civil lawyer lied during a proceeding to the court, you can bet they're very likely to have some discipline, either at a minimum a reprimand, but more likely suspension if they were caught lying in court. That prosecutor, nothing happened to him, and that's unfortunately too common.
Exactly.
What I would say to John is Steve Weinberg, who's was in this journalism school, did a national study on the problem of prosecutorial misconduct, focusing a lot on Brady. And while he wouldn't say it is as widespread as Bill suggests, he wouldn't also say it was as rare as John suggests. Right. It is a national problem. The fact that there aren't as many convictions overturned doesn't really get to the bottom line, because many times convictions aren't overturned based on materiality. The court says, yeah, there may have been a Brady violation, but it wasn't significant enough here, and that's post hoc analysis, and that's a problem. We don't want to put our courts in the position of having to make this after the fact determination. It's much better and more appropriate for this material to be turned over. And if a prosecutor isn't turning it over, whether it's material or not, he or she's not meeting their obligation, and there ought to be some consequences. And if there's no consequences, then this problem will continue to fester. So we've got to deal with it.
And ultimately, it's an issue of fairness, right? That's the whole point here, right? Charles, sorry, I think you wanted to jump in there a moment ago.
Well, I was going to say, kind of consistent with what Rodney was saying, is I think this idea of trying to hook this into the canons of ethics is something that really should be done, and we should. I mean, I think it's a great suggestion. There was the Champion, which is the magazine for the National Association of Criminal Defense Lawyers, did an article on Brady in May of 2013 that highlighted such cases as Senator Stevens' case and some other noteworthy cases. And one of the authors in that case was actually Barry Sheck, and an ex-judge named Nancy Gertner suggested that all Brady motions should also include reference to the canons of ethics and require the prosecutor to respond to specific sections of the canons of ethics, so that if there is a non-disclosure, you've got that situation set up.
Sure.
I used to do that in all my Brady motions, Charles.
Yeah.
but that's not a practice. A common practice is not something that's required.
No.
So, well, actually, that actually is all the time that we have. So I'm going to have to cut us off there. But I want to say thank you very much for listening today. That's it for today's Intersection. Thanks to our guests, Bill Ferguson, Ryan Ferguson's father, Rodney Uphoff, a professor in the MU School of Law and a former public defender, attorney John Roothouse, a former prosecuting attorney, and Charles Atwell is a practicing attorney who was formerly a circuit judge in Jackson County, who joined us by phone today. We'd like to remind those of you enjoying this as a rebroadcast that Intersection takes place live for a full hour from 2 to 3 every Monday afternoon. You can watch live streaming video of our program each Monday afternoon online at kbia.org. Alongside that video, you can submit your questions and comments and take part in an online discussion with others in the audience. You'll also find an archive of all of our past programs, including the full hour of today's conversation. Intersection is a broadcast from the Reynolds Journalism Institute and is a project of RJI and KBIA. Intersection is produced by Raymond Tungakar, Janet Saidi, and Ruben Stern. Travis McMillan's our technical director, with production assistance from Casey Morell and Andrew Yost. Pat Akers is our audio producer. Executive directors are Mike Dunn and Mike McKean. And I'm Ryan Ferguson. Thanks for joining us today, and have a great week.